big story that we've been tracking. Well, this has come as the top court of the country reversing one of what many deemed was a controversial order and judgment. Following a series of marathon hearings, the Supreme Court today pronounced its opinion advisory on whether it can impose timelines on the president and state governors for acting on bills passed by state legislatures. The unanimous opinion was that the concept of deemed assent is alien to the Constitution. The Supreme Court opinion noted that timelines cannot be imposed on the president or governors to decide on pending bills. However, they will take a decision on a reasonable time. Take a look at this report.
A crucial clarification from the Supreme Court on how India's federal system must function. The Supreme Court's 5-judge Constitution bench, led by Chief Justice B.R. Gawai, has delivered its much-awaited view on a presidential reference made by President Draupadi Murmu under Article 143 of the Constitution. The judges have said the court cannot prescribe timelines for president and governor, but they add that while governors are not rubber stamps, they cannot sit-stall bills endlessly. The court says actions of the governor are not justiciable, which means subject to trial, but adds that the court can give directions to the governor if there is prolonged inaction. The judges added that the concept of deemed assent used in the earlier verdict to pass the bills is alien to the Constitution. In short, governors must respond, but courts cannot set time frame for the Raj Bhavan to act. In April this year, a bench of Justice J.B. Pardiwala and Justice R. Mahadevan delivered a judgment in the state of Tamil Nadu versus the governor of Tamil Nadu case, in which the DMK government had accused Governor Ravi of withholding bills indefinitely. The court used its special powers under Article 142 of the Constitution to declare 10 withheld bills as deemed to have been assented on the date when they were presented to the governor. The legal fraternity was divided on the judgment, with some describing the verdict as judicial overreach.
He cannot withhold the bill without any reason. That is absolutely wrong, because he is not the king. He is only an appointed governor. If he thinks that he is a king, then it itself is against democracy. But this governor does not give any reason for withholding the bill.
In line of today's opinion, clarity is awaited on what happens to the earlier Supreme Court verdict.
The DMK has responded, stating that the governor in Tamil Nadu, Mr. Ravi, has a king-like attitude who acts at the behest of the BJP-led union government in the centre, is what DMK says. In fact, it also lashed out at Governor Ravi by saying that he who holds a constitutional position time and again deliberately makes politically motivated decision, thereby tarnishing the dignity of his position, is what the DMK says. With camera person Bidesh, Anaga Keshav reporting for India Today from Chennai.
I want to quickly bring in my colleague Anisha Mathur, who tracks not just the Supreme Court, but is our correspondent who tracks all legal affairs. Anisha, break it down for us, cut out the legal jargon. With what many are seeing was the Supreme Court reversing its old order, old judgment, where 3 months were given for the governor to not sit on bills. There was a time frame, and now it seems that the Supreme Court has reversed its order.
Well, Preeti, that is exactly what has happened. In this advisory opinion, the Supreme Court has held that the April verdict, where the court had set a 3-month timeline, was constitutionally incorrect, because the court has said judiciary cannot give a timeline to the governor or the president. What it can do, however, is a call for a reasonable time to be followed if there is an inordinate delay by the courts. Effectively, Preeti, what we are going to be seeing is that the next time there is a standoff between the governor and the state, there will be another case coming in to the High Court of that state or to the Supreme Court, where the state will have to show that the governor has been sitting on this bill. What is also very important is the court very clearly saying that the governor does not have any authority under the Constitution to stall a bill. He can either assent, that is, give approval, or send it to the president for reference in case he believes that there is some constitutional question, or he can send the bill back to the assembly with his objections and concerns. However, the stalling, the pocket veto, that is something that the states had come to court about, which is what the Tamil Nadu case was all about as well, and Punjab and Kerala, that the governors were sitting on bills for months on end, that even this advisory opinion has clearly said is not under the power of the governor, even under Article 200. What is also interesting to note is that the court has held that the work of the governor and the president is not justiciable. That means the courts cannot go into why they have taken the decision that they have, but the court can step in if they fail to take a decision.
Right.
So we're probably going to see more political standoffs and more legal battles.
Right.
Back to you.
You know, it's very interesting because that order was one of the most controversial orders, deeply debated, especially had the legal fraternity split. And now you have the top court of the country reversing that order of a 3-month stipulation on whether or not the government or the governor can sit on a bill or action. 3 months were given the last time, and now that has been reversed.